The smell reached her before she saw the drift. It was a Tuesday morning in July of 2011, and Ellen Marsh was in the cab of her Massey Ferguson 5455 on the east edge of her property in Benton County, Indiana, doing the mid-season walk of her soybean rows the way she did every July, slowly, systematically, looking at canopy closure and leaf color and the specific visual vocabulary of a crop that is either doing what it is supposed to do or telling you why it isn't. The smell was herbicide, not the faint trace of chemical that drifts occasionally from distant application. The concentrated, unmistakable presence of something that has been applied nearby and recently. Ellen shut the tractor down and climbed out and stood in the field and felt the wind. It was coming from the north, from the direction of the Crestline agriculture operation that had purchased the 760 acres adjacent to her north fence line 18 months earlier. She walked to the north fence. On the other side, a spray rig was moving through Crestline's field in the direction that would have brought it parallel to her fence line approximately 40 minutes earlier. The pattern of the spray, the wind direction, and the timing were not ambiguous. Ellen stood at the fence and looked at her soybeans on her side and understood, before she walked back to look more closely, what she was going to find. She found it on the walk back. A band of damaged plants running parallel to the north fence line, approximately 60 feet wide, varying in intensity from severe curl and yellowing at the fence to progressively milder symptoms further into her field. The damage pattern was consistent with herbicide drift from a ground-applied sprayer operating in a wind that had carried the chemical across the fence line and into the adjacent crop. Ellen Marsh was 53 years old. She had been farming her 240 acres in Benton County since 1998, when she and her husband Carl had left teaching careers in Indianapolis to take over Carl's family farm. Carl had died in 2006. Ellen had continued farming alone, a decision that most people in her county had expected to last one season, and that had now lasted 5 years and showed no sign of ending. She had converted 40 acres of her operation to certified organic production in 2004. The certification had taken 3 years to achieve: the required transition period, the documentation, the third-party inspections, the specific discipline of an operation that cannot use synthetic inputs and cannot be contaminated by them. The 40 certified acres were her highest margin ground. The organic soybean premium that year was running at $4.20 per bushel, above conventional. On 40 acres at an average yield of 48 bushels, that premium represented $8,064 per season. 22 of those 40 acres were in the band that the herbicide drift had reached. Ellen stood in her field in July of 2011 and understood what had happened and what it meant and what she needed to do. She went back to the tractor, drove to the shed, and called her attorney. Ellen had retained Margaret Holloway, the same agricultural attorney who had handled Carl Brenner's wrongful repossession case 4 years earlier, in 2009, when a boundary dispute with a different neighbor had required legal counsel. The dispute had been resolved without litigation. Ellen had kept Margaret's number. She called it on the afternoon of July 19, 2011, and described what she had found. Margaret asked 3 questions. Had Ellen documented the damage? Ellen said she had taken photographs. Had Ellen preserved any plant samples? Ellen said she had not yet, but could. Had Ellen contacted her organic certifier? Ellen said she was calling Margaret first. Margaret said call the certifier today, before anything else. The certification status of those acres is the central issue, and the certifier needs to know immediately. Then document everything you can: photographs, GPS coordinates of the affected area, wind direction records, any witnesses. Don't contact Crestline yet. Let me do that. Ellen called her certifier, the Indiana Certified Organic Program, that afternoon. The certifier sent an inspector the following day. The inspector walked the affected area, took plant and soil samples, noted the damage pattern, and filed a preliminary report. The preliminary report documented chemical contamination on 22 acres of certified organic production. The certification of those 22 acres was suspended pending investigation. Suspended certification meant Ellen could not market the soybeans from those acres as organic. she would sell them as conventional. At that year's prices, the difference was $4.20 per bushel. On 22 acres at 48 bushels per acre, the immediate income loss was $4,432 for the 2011 season alone. That was the immediate loss. The larger problem was the certification itself. Once a certified organic field is contaminated by prohibited substances, restoring the certification requires completing the transition period again, 3 years from the date of confirmed contamination before the acres can be recertified. 3 years of selling 48 bushels per acre at conventional prices instead of organic prices. 3 years of $4,432 per year not earned. The total projected income loss from the loss of certification, calculated across 3 years, was $13,296. Margaret noted the calculation. Then she noted what she called the secondary losses, the costs Ellen would incur to document the contamination, to pursue recertification, to manage the affected acres through the transition period, and the intangible but real cost of the time Ellen would spend on the legal process instead of on her farm. She said these would be addressed in the claim. She called Crestline Agriculture on July 21st. Crestline Agriculture was a corporate farming operation headquartered in Des Moines, Iowa, that managed approximately 42,000 acres across Indiana, Illinois, and Ohio. The Benton County property had been purchased in January of 2010 as part of a regional expansion. The operation was managed locally by a field manager named Brad Tully, who was based in Attica and responsible for the day-to-day decisions of the Benton County operation. Margaret reached Brad Tully on July 21st and described the contamination event. Brad said he would need to review the spray records and consult with his supervisor before responding. Margaret said she would expect a response within 5 business days. Brad said he would do what he could. The response came on July 28th, 7 days after Margaret's call. It was from Crestline's legal department in Des Moines, not from Brad Tully. The letter acknowledged that Crestline had conducted herbicide application adjacent to Ellen Marsh's property on July 19th. It stated that Crestline's records showed the application had been conducted within label requirements and that the company could not accept responsibility for drift events caused by wind conditions that were within normal agricultural operating parameters. It offered to have an independent agronomist assess the damage and provide a recommendation. Margaret read the letter and noted the specific language, drift events caused by wind conditions. The letter was placing responsibility on the weather rather than the operator. The legal position it was establishing was that Crestline had applied herbicide correctly and that if any drift had occurred, it was a result of natural conditions rather than negligent application. Margaret filed suit in Benton County Circuit Court on August 15, 2011. The complaint alleged 4 causes of action: negligence in herbicide application, trespass to land by chemical intrusion, private nuisance, and strict liability for abnormally dangerous activity. The strict liability count was the aggressive one. It argued that pesticide application near certified organic production constituted an abnormally dangerous activity for which Crestline was liable regardless of whether the application had been conducted negligently. It was a theory that had not been widely tested in Indiana agricultural courts. Margaret included it because the facts supported it and because its presence in the complaint would signal to Crestline's legal team the seriousness of the litigation. Crestline's legal team was a firm in Indianapolis with an agricultural practice group. They filed a motion to dismiss on September 30th, arguing that the complaint failed to state a cause of action on all 4 counts. The motion was denied in December. The court held that all 4 counts presented viable theories of liability that could not be resolved without factual development. Discovery began in January of 2012. The discovery process in agricultural contamination cases turns on evidence that is often fragile and time-sensitive: plant samples, soil samples, spray records, weather data, equipment calibration records, operator logs. Ellen had preserved plant samples from the affected area in the week following the contamination event, following instructions from her certifier and from Margaret. The samples had been analyzed by a laboratory in Lafayette, that specialized in agricultural chemical analysis. The analysis confirmed the presence of a herbicide compound consistent with the product Crestline had applied on July 19th in soil and plant tissue from Ellen's field. The weather data was public record. The National Weather Service station nearest to Ellen's property showed wind speed and direction on the morning of July 19th. The wind had been from the north-northwest at 8 to 12 miles per hour during the hours of the application, conditions that fell within the label restrictions for the product Crestline had used, but conditions that an experienced operator applying herbicide adjacent to organic production should have recognized as creating a meaningful drift risk. The operator logs and equipment calibration records were the subject of a contested discovery request. Crestline initially refused to produce the operator's log for July 19th on the grounds that it contained proprietary operational information. Margaret moved to compel production. The court ordered production in March of 2012. The log, when produced, showed that the operator had noted wind conditions at the start of the application and had proceeded without adjustment to boom height, application pressure, or nozzle configuration, three technical variables that could have reduced drift potential under the existing wind conditions. Margaret retained an agronomist expert, a retired extension specialist from Purdue University, who had spent 31 years advising farmers on pesticide application, to review the records. The expert's report concluded that a reasonable and prudent pesticide applicator, aware that the adjacent property contained certified organic production and operating in the wind conditions present on July 19th, would have implemented drift reduction measures not present in Crestline's application records. Crestline retained their own expert. The competing expert reports established the factual dispute that would go to trial. The trial began in September of 2013, 26 months after Ellen had stood at her north fence and smelled the drift. Ellen had farmed through the 2 years of litigation the way she had farmed through everything since Carl's death, by continuing. The 22 affected acres had been managed through the conventional protocol that their suspended certification required. She had planted them, fertilized them with conventional inputs, and sold the crop at conventional prices for 2 consecutive seasons. The income loss had been real and had been absorbed by the operation's cash reserves and by adjustments to her personal spending that she did not discuss with anyone. The Massey Ferguson 5455 had run through both seasons without significant mechanical issue. Ellen maintained it the way she maintained everything in her operation, by the schedule, by the service manual, by the specific attention of a woman who understood that the machine's reliability was not incidental to the farm's survival, but central to it. She changed the oil every 100 hours. She replaced the filters when the hours required. She did the pre-season inspection in March of each year and noted everything she found and addressed everything that needed addressing before the ground was ready. During the months when the litigation required her presence at depositions and hearings and meetings with Margaret, she adjusted her farm schedule and made up the hours at the margins of the day. She did not let the litigation become the thing she was doing instead of farming. Farming was what she was doing. The litigation was the mechanism by which a wrong was being addressed, and the mechanism required her time and attention, and she gave it both without allowing it to replace the primary work. There were people in her county who assumed the lawsuit was the story, that Ellen Marsh was a farmer who had been wronged and was spending her energy pursuing the wrong through the courts, and that the farm was secondary to that pursuit. This assumption was incorrect in the specific way that assumptions about farmers are often incorrect. It placed the institutional event in the foreground and the farming in the background, when the actual relationship was the reverse. The farming was always in the foreground. The lawsuit was behind it, being pursued with the hours that the farming left available, which during critical periods of the season were few, and during the winter months were more. She filed discovery responses in January from the kitchen table at 6 in the morning before going to the shed to start the tractor. She reviewed deposition transcripts on evenings when the field work was done and the maintenance was caught up. She drove to Lafayette for meetings with Margaret on days when the weather didn't permit field work, and there was nothing in the shed that couldn't wait until she returned. The farm did not stop. The lawsuit did not stop. Both continued, in parallel, because both were necessary, and because Ellen Marsh was not a person who allowed necessity to determine what she was capable of. At trial, Crestline's defense rested on three arguments: that the application had been conducted within label requirements, that drift under the existing wind conditions was a foreseeable but legally acceptable risk of normal agricultural operations, that the damages claimed were speculative because organic certification could not be guaranteed, regardless of contamination. Margaret's case rested on the evidence that discovery had produced: the weather data showing conditions that created meaningful drift risk, the operator log showing no drift reduction measures had been implemented, the expert report concluding that a reasonable applicator would have implemented such measures, the laboratory analysis confirming the presence of Crestline's herbicide in Ellen's soil and plants, and the certification records documenting the suspension of 22 acres of certified organic production and the 3-year timeline required for recertification. She also introduced evidence of the premium income that the certification represented: the $4.20 per bushel differential, the 48 bushels per acre yield, the 22 acres, the 3 years. The mathematics was straightforward, and the jury could follow it. The jury deliberated for 2 days. On the third day, they returned a verdict for Ellen Marsh on 3 of the 4 counts: negligence, trespass, and nuisance. The strict liability count failed, the jury finding that herbicide application did not constitute an abnormally dangerous activity under Indiana law. The court had anticipated this possibility and had instructed the jury that the 3 remaining counts were independently sufficient for a liability finding. Actual damages were assessed at $162,000, covering the 3 years of lost organic premium income, the cost of the contamination documentation and analysis, the legal costs of the litigation, and a portion of the time and management disruption Ellen had sustained across 26 months of proceedings. Punitive damages were assessed at $318,000 based on the jury's finding that Crestline had operated with conscious disregard for the risk its application posed to adjacent organic production. The operator's log, showing awareness of wind conditions and no responsive adjustment, was the central evidence for the punitive finding. Total verdict: $480,000. Ellen Marsh was sitting in the third row of the courtroom when the verdict was read. She had been in the proceedings long enough to have stopped being surprised by things, and the number, when the clerk read it, landed with the specific weight of a thing that has been coming for 26 months and arrives without the drama that the anticipation suggested it would have. She thanked Margaret in the hallway afterward. Margaret said the case had been straightforward. The evidence had been what it was. The jury had done what juries do when the evidence is clear. Ellen said it had not felt straightforward from inside it. Margaret said it rarely did. Crestline appealed. The appeals process extended through 2014 and into 2015. The appellate court upheld the verdict on negligence and trespass, reversed on nuisance, and reduced the punitive award from $318,000 to $240,000, citing proportionality standards. The total award after appeal was $376,000. Ellen received the payment in February of 2015, 3 years and 7 months after the Tuesday morning she had smelled the drift from her tractor cab. She used a portion of it to fund the recertification of the 22 affected acres, which completed their 3-year transition period in 2014 and were recertified for organic production in the spring of 2015. The remaining funds went into the operating reserve she had been building since Carl's death and that the litigation years had drawn down. In the spring of 2015, for the first time since 2011, Ellen Marsh planted certified organic soybeans on all 40 acres of her organic ground. She noted it in the Farm Journal, April 22, 2015, full organic acreage restored. She put the journal back on the desk and went out to do the final pre-plant check on the Massey Ferguson. Ellen Marsh still farms 240 acres in Benton County. She is 66 years old. The 40 certified organic acres have been producing at full certification since 2015. The Massey Ferguson 5455 has 14,000 hours on it. The engine has been rebuilt once. The hydraulic pump has been rebuilt twice. The cab that smelled the herbicide drift on a Tuesday morning in July of 2011 is the same cab it has always been. Crestline Agriculture sold its Benton County operation in 2018. The 760 acres adjacent to Ellen's North Fence are now farmed by a family operation from Fountain County that has been a neighbor in the way that neighbors are supposed to be, present at the fence line when presence is appropriate, and absent from it when absence is appropriate. Ellen has not had a herbicide drift event since 2011. She monitors the north fence line at every application season, the way she monitors everything, with attention, without anxiety, with the specific watchfulness of someone who has learned what inattention costs and does not intend to learn it again. Brad Tully, the Crestline field manager who had managed the Benton County operation in 2011, left the company in 2013. Ellen does not know where he went. The operator whose log had shown wind conditions noted and no action taken, that person's name does not appear in the public record of the case. Ellen does not think about either of them. She thinks about the farm, about the 40 acres that took 7 years to build to full organic certification the first time and 3 years to rebuild after the drift, about the specific discipline of an operation that cannot use synthetic inputs and cannot be contaminated by them, and must be managed accordingly across every decision and every season and every interaction with the land and equipment and conditions that define a farming year. The Massey Ferguson is in the shed. The organic acres are certified. The Farm Journal has the April 2015 entry, full organic acreage restored. Beside the July 2011 entry, drift event, north fence line, certifier notified, Margaret called, and all the entries between them. A wrong had been done. The documentation had been preserved. The court had said what the field had said on the morning the smell reached her before she saw the drift. $480,000 was the jury's number. $376,000 was what the appeals court affirmed. The 22 acres were recertified in 2015. Ellen had been farming them correctly since 1998. She intended to keep farming them that way. That had always been the plan. Nothing that had happened between 2011 and 2015 had changed the plan. It had only confirmed that the plan was worth protecting.